Hello, my name is Beth King-Smith. I'm a partner here at the firm Harrison Clark Rickabees. I'm here today with my colleague Caroline Cowley, and today we, as members of the Disputed Wills, Trusts and Estates team, are going to have a conversation about the merits of settling will disputes by way of a mediation. So Caroline, what is a mediation?
Thanks, Beth. A mediation is effectively a settlement meeting, and it's done in a very specified way. Each party, with their legal representatives, is in their own room. There is then a mediator, and this person, who is usually legally trained, and quite often in our area of work, they have a level of expertise in probate and will disputes, and they effectively facilitate the settlement. So they will move between the rooms, talking to all the parties to see if a suitable settlement can be reached. It can take up to a day. It can be a matter of hours, and quite often, in our experience, Beth, they can go on late into the night, into the early morning. But what it means is it gives each party the opportunity to air their concerns, to talk about all the issues around the dispute itself, but they don't have to actually come face to face with the other parties. Now, the mediator, it's important to remember that they are not a judge, and they're not going to find any fact of law, and they're not going to make any determination on the dispute in question. But what they will do is just talk through the options with each party to see if they can make them understand that the compromise is the best way to deal with this particular dispute. And actually, quite often it works. I know we do a lot of mediations in our team. And what do you find are the main advantages of mediation?
I think some of the main advantages are getting the dispute over with, because quite frankly, sometimes litigation can take 18 months or 2 years. And in that time, people have got to live their lives. And it's not just the actual monetary cost of disputing wills or litigation. It's also the emotional cost. What's the cost emotionally to you and your family of that going on? So one of the things I hear lots of clients say is that they actually want to bring a resolution and they want to be able to move forward with their lives. And so mediation we can often arrange much more quickly than waiting for a final court hearing. About 90% of our cases, I'd say, that settle outside of the court. So the types of disputes we do, will challenges, removal of executors, undue influence, these sorts of things can actually be much better resolved in the privacy of a mediation, because it's all confidential to the parties on that day. And that can be quite helpful in small communities, like farming communities, where you don't necessarily want everybody knowing your business and it all being dragged through the courts. It can be emotionally very stressful. We are big advocates of mediation. Anything that helps the parties narrow their disputes and settle cases sooner than having to wait for court dates is, in our experience, a huge advantage.
Yeah.